What's going on, everybody? Welcome to the video. And in this video, I'll be discussing the top 5 things that you should not include in a will. All right, first, let's say what a will is. A will is a set of instructions that you'll leave to the court on how they should distribute your property after you pass away. And I think there's a common misconception that once you've done a will, you don't have to go to the probate court and do a succession. So what the will does is get you out of the set rules or the set laws where your property goes. For example, if you have children, but you want to leave your property to your grandchildren, you have to write a will, because otherwise the law would just give all your property to your children and not your grandchildren. A will does not alleviate the need for you to go to probate court and do a succession. So when you do a will, your heirs are still going to have to go to a court, provide that will, actually probate that will, and then get the property transferred, which is another legal process and another cost. My name is Ryan Hamilton. I'm licensed to practice in the state of Louisiana. And here in this channel, I give estate planning tips on successions, trusts, wills, donations, things like that. So if you need more information on those topics, please like this video and subscribe to my channel. Number 1, retirement accounts. Retirement accounts have designated beneficiaries. When you set up the account, you normally list those beneficiaries and also provide a secondary beneficiary. So if you attempt in your will to state someone other than who was listed as a beneficiary of that account, it won't be valid. What was listed on the account would always trump what's in the will. Number 2, insurance policies. Just like retirement accounts, insurance policies have designated beneficiaries. So any attempt in a will to name a different beneficiary or someone different that's listed in that insurance agreement is going to be null and void. Number 3, property that's in a trust. If you've established a trust and you've transferred property from your name to the name of the trust, if you attempt to leave something in a will that has already been transferred to a trust, it won't be a valid bequest, because those assets technically are not owned by you, they're owned by the trust, and they will be governed by the trust document, which has named beneficiaries. So whoever is listed in that trust document as the beneficiary is going to get the property. Number 4, property jointly owned that has the right of survivorship. This isn't common in Louisiana. However, other states it's more common. If you own a property jointly with someone and it has the right of survivorship, meaning that if you pass away, they get all the ownership. You couldn't leave a clause in your will saying, I leave my interest in this LLC to another person, because the articles of organization of that LLC and the bylaws of that LLC say that when you pass away, the property goes to the remaining members. And finally, number 5, attempts to place restrictions on property given to your heirs. You can't do that through a will. For example, let's say you have young children or young grandchildren or even older children that you want to leave a large sum of money to, but you don't want to give it to them all at one time. So let's say you want to leave them $200,000, but you say they can only get $20,000 a year. You can't do that through a will. The only way to do something like that is to establish a trust and have a trustee manage the funds and have the trustee give that person the $20,000 a year or whatever amount that you decided to give. Another thing that you could not do is leave property to your children and tell them that they can't sell it. That's not what's going to happen. The judge is going to give them a judgment of possession that's going to place that house in their name, and they'll have a full right to sell it. If you want to place limits on property, if you want to place restrictions on the right to sell property, the proper venue or the proper avenue to use for that is a trust, not a will. So if you made it to the end of the video, thank you for watching. If you know anyone who can get value from this content, please consider sharing it with them. Thank you.